have an amazing speaker who's going to talk to us a little bit about some of the work that he's done. This is Professor Joel Quirk. And Professor Joel Quirk is a professor of politics at the University of Witwatersrand in Johannesburg. His research focuses on enslavement and abolition, gender and violence, historical repair, and the history and politics of Africa. Professor Quirk is the author or co-editor of 8 books, the most recent of which is entitled Research as More Than Extraction, Knowledge Production and Gender-Based Violence in African Societies. Professor Quirk was a member of the Yale Working Group on Modern Slavery, rapporteur of the UNESCO Slave Route Project, Resistance, Liberty, and Heritage, and is a founding editor of Open Democracies Beyond Trafficking and Slavery. Thank you so much, Professor Quirk, for joining us today.
Thanks, Carmen. I have to confess I'm incredibly inspired to learn about all of the work that's been going on in different states in the United States and collectively within the nation as a whole. It's remarkable just how much energy and activism has been kind of devoted to the question of slavery and its legacies. So in this context, I want to speak briefly to you all about a key theme in my work, which is how the history of enslavement and legal abolition can be connected to practices today. So I'm going to dive into this question of how we might think about defining slavery and how a definition of slavery might be applied. So my starting point, if I can have my first slide, is for thinking firstly about the disconnect between the legal abolition of slavery and what I've described in my work as larger questions of effective emancipation. So I don't need to tell you all this, but it's been very easy to declare the problems associated with enslavement to be solved or resolved simply by dint of the passage of legislation, or in the United States, the passage of constitutional reform. So my question, if I can have my next slide, relates, back please, relates to the question of what counts as slavery once slavery has been abolished as a legal institution. And this is a question that has a legal issue where if you want to charge someone for enslaving someone else, you need to have an understanding of the elements of crimes associated with enslavement as a legal institution. But it's also a political question because it's very easy to white-hat conversations around slavery where questions about whether something is really slavery come kind of quickly and easily in context where there's a strong social and political impulse to try and push slavery as far in the past as you can, even though we know, of course, that its afterlives continue in various forms. So in my work and in this presentation, I want to take you through an answer to the question of what counts to slavery in the aftermath of legal abolition. And I want to set this up by firstly thinking about a couple of ways in which the label of slavery might be stretched or diluted. We know that there's rhetoric associated with slavery as a category. We can talk about wage slavery. We can talk about slavery being applied as a label for all kinds of things. And this runs the risk of creating suspicion about whether anything can be really defined as slavery. And also, and I think crucially in this context, there's a risk that indiscriminate references to slavery can dilute or sideline histories of enslavement and their racialized legacies. So here I follow Adele Blackett in insisting that slavery is not simply a metaphor. It's not something that should be lightly applied to any number of different things. It just needs to have weight and meaning. And then secondly, I follow Lindsay Butens, who published a book with Duke University Press recently, pointing to the risks in having slavery applied indiscriminately such that it links up to white savior narratives of rescue associated with all kinds of different issues. And Buten's argument is that sometimes work associated with human trafficking can displace and marginalize questions around racial justice. So it's in this context, my question becomes how to credibly define and apply enslavement. And I want to suggest here that slavery cannot be everything, but it also cannot be nothing. So in my next slide, I have a brief account of what an answer to this question might be. So as part of a larger conversation around how slavery looks from a legal perspective, some colleagues and I want to stress that this is not only my work. There's a series of historians and activists and so on who contributed to these guidelines. We looked at how slavery is defined in law, and we particularly looked at the idea associated with the 1926 Slavery Convention, which the United States, like many other states, has ratified, which understands slavery as the status or condition of a person over whom any or all of the powers attaching to the right of ownership are exercised. Now, this definition is important for several reasons. It firstly gives us an answer to the question where slavery cannot simply be de jure in law or policy. It needs to be understood as having de facto dimensions. So when we talk about powers attaching to the right of ownership, we can talk about powers that are exercised even if they aren't formally recognized as enslavement in law. And what this means in de facto terms is that there will be situations where powers are exercised even if they are not formally described and classified as being enslavement. And what that means is when looking to see whether something meets the threshold associated with enslavement, we can't simply take the word of the people who describe certain categories as not being slavery. So, and in my final slide, the key predicate condition here is the idea that slavery can be defined in terms of powers attaching to right of ownership as constituting control over a person in such a way as to deprive them of their liberty, intent to exploit, use, manage, profit, transfer, or dispose of that person. So what this definition gives us, or at least what I hope it gives us, is an understanding that slavery exists in fact, even if it isn't recognized as such in law. And crucially, this is a definition of slavery that's being used for the purposes of criminal prosecution. So the International Criminal Court, under the terms of the Rome Statute, uses this definition of slavery to convict people of it as a criminal status. And the most recent example we have of this is the case of Dominic Ongwen in Uganda. So for my purposes, I want to suggest that powers attaching to the right of ownership can and should be applied to the circumstances of many, but not all, of the people subject to the prison industrial complex. And here, I also want to briefly end by saying it's a mistake under this definition to understand slavery as an individualized relationship between an enslaved person and their enslaver. Slavery historically was both an individual relationship and a collective status enforced by the state through surveillance and violence. And similarly, in the United States today, we have to understand this as a product of state policies, a product of state systems, and a product of private and public partnerships, all of which involve a collective dimension. And then finally, we can't simply reduce powers attaching to right of ownership to people being forced to labor for no pay. So enslavement is horrifying. It involves incredible amounts of physical violence, but it's a mistake to only look at bodily suffering over the less visible yet still massively harmful psychological and social effects of enslavement. So slavery is not simply a system of extreme violence and terror, it's also a system of extreme subordination and discrimination that places extreme restrictions on movement, community, work, and family. So slavery is still monstrous even without extreme bodily suffering. And it's in this context we need to understand the prison industrial complex as involving violence and exploitation and marginalization that go beyond simply work for no wages. It's a totalizing system, much in the same way that racialized slavery in the United States was a totalizing system. Thank you.